SJC-10588, Bronson versus Contributory Retirement Sales Board.
Good morning. May it please the Court, I'm Joseph Sanduli for the three teachers who are seeking to purchase their service at private special needs schools. The specific statutory question before you is whether Social Security is, quote, a retirement allowance, annuity, or pension from any other source. As you've seen, the statute, Chapter 32, Section 41P, permits teachers to purchase service, retirement service, at a private school that's funded by the Commonwealth. I want to point out to you first that this statute was enacted just a year after Chapter 766, the statute requiring special education for special needs children.
Can I ask you a factual question, though? And I'm not sure it's raised by anybody, but the three plaintiffs, one's a psychologist, one was an administrator, and one, I forget what the third one. But is there any issue about whether they fit within the language of 401P
Your
about
Honor,
teaching pupils?
There is an agreement between the parties that specifies certain other issues will be litigated later on once the Social Security issue is resolved.
Oh, okay.
It's part of a decree before the Superior Court consolidating the three cases.
I'm sorry, I missed that.
Yes.
Okay.
So that is not those are not issues that the court needs to be concerned with today. But
now,
let me answer that.
I'm sorry.
Let me answer the question that I've posed to you, because I think the case of State Tax Commission versus Gray has a greater significance, I think, than we even attributed in our brief. That's the case of 340 Mass 535, 1960. And that was the law before 41P was enacted. And in that case, the Supreme Judicial Court held for the law of Massachusetts that a retirement allowance from any person, that's a quote of the tax statute, Chapter 62, Section 5B, that a retirement allowance from any person did not include Social Security. That Social Security was not taxable under that statute. And the court, so that holding was essential to the case, and the court gave the reasons that we've been arguing in this case, that Social Security is something apart and distinct from a retirement allowance, annuity, or pension. What the court said there was that because Social Security is not from a former employer and not based upon any contract of employment, but based upon a separate statutory provision, it is different. It is not a retirement allowance for the purposes of the law of Massachusetts. They used this other language that, quote, Social Security is neither wholly in the nature of a pension nor wholly the nature of an insurance payment. It's a unique and novel solution to a social problem. That, Your Honors, was the law of Massachusetts at the time that 41P was enacted. Now, there are many other reasons why.
If I could step back, if you were right, am I correct that if you have two persons, one who teaches for 20 years in a public school and gets only their teacher pension, and one who teaches for 16 years in a public school and 4 years in a private school funded with public money dealing with special needs students, that the latter teacher actually is better off on retirement because he or she will now get both a teacher pension and some Social Security?
Well, we don't know whether if the teacher only worked 4 years in the private school that was covered by Social Security, she's not going to get any Social Security. She's worse off because she's contributing.
She has other employment for the other 6 years.
Well, if you modify it that way, true. But if the person simply contributed for 4 years to Social Security, she'd be out of pocket for that contribution without any benefit.
Right, but am I correct?
Assuming she works in the Walmart some point during summers or in high school.
But I understand your brothers to be saying that if this person is not eligible for Social Security, they would say she can buy in. If your client were to say, I'm not eligible for Social Security, I've only got 4 years total, that she'd be able to buy in.
That's correct, if there were no more Social
Okay,
Security service.
so this case only addresses those who are eligible for Social Security and for a pension.
Correct, Your Honor. But the question of who is eligible for Social Security sometimes is a slippery subject. That is, a person may work for the private school for a certain period of time and then may pick up service elsewhere. So it's not always apparent when they've satisfied their 40 quarters for Social Security. But I think that the real point here is the Commonwealth, when they enacted this statute, was trying to induce private school teachers to come into the public system because they needed special needs teachers at this point. They had just enacted 766. They had a whole new program that they had to satisfy, and they were trying to attract these teachers by offering them credit for their private service. And I don't think the teachers were, trying to parse this language. I think they were working for private schools. They were induced to come to Massachusetts and to teach in our public school system. That was the salutary purpose of the statute. Now, the Attorney General's view at the time was that everybody would have been covered.
I mean, that statement you just made, is that found as a legislative history?
You know where I found it, Your Honor? It was in the Special Commission on Retirement that was published in 2009. They characterized this 401p in that fashion, that it was to induce teachers to come to Massachusetts. I would also see it as a reward for teachers who were essentially in the public sector, although working for a private contractor. They're working for private schools that was funded completely by the Commonwealth of Massachusetts. So I can see where the legislature may have had some concern for rewarding them. But the real question here is the statutory question, what the legislature meant at the time that it used those words, retirement allowance, annuity, or pension from any source. And we had a very clear answer in the Gray case. And that distinction has been reinforced by the court later, of course, in the Mahoney case that we cited as recently as 1997. There, it was a marital property case, and the question of whether Social Security was a, quote, retirement benefit within the meaning of the marital property law of 208, Section 34. And while, and the court offered exactly the same distinction between Social Security and retirement benefits that it did back in 1960, when it said that because there is an important difference between the pensions and Social Security benefits, it is appropriate for a judge to treat public or private pension funds differently from Social Security old age benefits for the purpose of marital property distribution.
Can I ask you a question? Because you said it's a slippery slope trying to figure out who's eligible for Social Security. And I have to agree that this amicus brief makes it almost impossible to understand who's eligible for Social Security. Do you understand what they mean here when they say public employees essentially are not eligible for Social Security, no matter how many quarters they may have assembled?
Well, I think what they're talking about are people who work just for the Commonwealth. What they address in the amicus brief, actually I think it works to my favor, they talk about this Chapter 118C, Section 3. And this is a section that allows the Commonwealth of Massachusetts to bring Social Security for people employed by instrumentalities of the Commonwealth. And what's interesting about it, Chapter 32, Section 2, then says if you're covered by Social Security under 118C as through the instrumentality, then you don't get a public pension. And they argue that that should be read to preclude anybody who gets Social Security from any source, when in fact the exclusion in 32 Section 2 is a very narrow exclusion. It says only if you're getting Social Security through 118C. But let me ask you to look at that more closely, because I think it sheds light on the meaning of our statute, of 41P. You'll notice that the way it refers to Social Security, when 118C refers to Social Security, it calls it a federal old age and survivors insurance system. Doesn't call it a retirement, a pension, or an annuity. And in 32 Section 2, where it excludes from the pension system, people who are getting Social Security under this 118C, the phraseology it makes express reference to Social Security coverage. And these statutes were in effect back in 1951, I believe, is when they came into effect. So the legislature knew how to exclude or how to refer to Social Security in its enactment of statutes, and it did not put Social Security in 4.1p as a disqualifier. I also want to point out...
Mr. Sandulli, your time is up.
Could I just
Thank you,
ask
Your Honor.
one, this is a factual question. Is it in the appendix, that agreement that you told me about at the beginning? The one where you put aside other issues?
No, I don't believe it is, Your Honor.
Would you send in a 16L letter and just explain that fact?
Of course.
Thank you.
Of course.
Just so we know what we're dealing with.
Will do. Thank you.
Thank you.
Good morning. Assistant Attorney General Rob Quinnen for the Contributory Retirement Appeal Board. This court should accord substantial deference to CRAB's current construction of Section 4.1p. As this court stated in the case of Foresta versus...
Just by way of clarification now, is it correct that CRAB has, in the past, gone the other way on this topic?
CRAB has only once construed the section at issue here, and that was in the Sigmund case. And in that case, CRAB is aligned with the teachers here. In the Rosing and other cases that are before this court, CRAB summarily affirmed a Dalla magistrate's decision that ruled in favor of the teachers' retirement system.
So it has gone both ways.
Well, it never engaged in any independent analysis of the statute. It simply summarily affirmed a magistrate's decision that itself was not, did not contain much analysis, that rested on two appeals court decisions, the Dubé case and the Flaherty case, that in fact are not really relevant here.
Could you do me a favor? Could you explain what the State Retirement Board is trying to say here, why it is that we should affirm
well,
the
I think
Superior Court?
what they are saying is that Social Security should not be viewed as a complement to state pensions. It is rather a substitute for state pensions. But the important point is that that's only true with respect to people who are state employees. Here we're dealing with teachers who were private employees and are seeking to...
You mean getting Social Security? You mean a class of state employees who is, while being a state employee, getting Social Security? Is that what you mean?
That's right. And there, in very rare circumstances, there may be a situation where a state employee might be eligible for Social Security benefits because they're not part of the state retirement system.
Oh, so
But
if you had it before
But that's
you
a whole
became,
different-
if you had Social Security before you became a state employee, that's not what's covered.
That's not at issue here. Right. I mean, I myself am someone who will be entitled to Social Security benefits, but I will also get a state pension once I have 20 years of
That's
state
really
service.
not what the board says, though. The board seems to be saying something else. It is very complicated, I have to say, as to who is entitled and when. So you're saying that if one of these teachers had worked 20 years in the private sector and had accumulated and paid Social Security in that regard, and then worked another 20 years earned a public pension, that somehow they could collect both, not just one.
That's right. And there's also a federal law, the offset provision, which reduces the amount of Social Security benefits that a state employee, such as myself, will receive.
And what's this 218 agreement in 1952, which they say essentially means that public employees can't get Social Security?
Well, basically, it was the federal government permitting Massachusetts to set up an alternative to Social Security, not requiring the Commonwealth to make contributions to the Social Security system.
And so I'm trying to understand why they're arguing against you here.
I think they're making a point that with respect to state employees only, not these people, that Social Security is not a complement. It is that once you become a state employee, you are paying into a different state pension system. It's a substitute. The state pension system is a substitute for Social Security.
I understand that, but I don't
Right.
understand why that leads them to be arguing against.
I don't believe it is relevant.
Okay, well, maybe that's helpful.
Yeah.
Could you explain to me how the mechanics of the buy-in? Do the teachers who were in these private schools actually have to take money and pay in?
Yes.
And what's the formula? How does that work?
I don't know the particulars. I do know that they are required to pay for the credits while they were private school teachers. And in this circumstance, of course, they were all performing a public service.
Yeah, is it a nominal amount, or is it an amount that's fairly comparable to what they would have contributed if they had been earning and teaching in the public school
Isn't it
system?
5% of what their salary was in the years in question?
That's right, Your Honor.
Yeah.
It is.
Okay.
It is. So Crabb came to the conclusion it did based on a 1975 Attorney General opinion. Secondly, because of the absence of any mention of Social Security benefits in the statute, contrasted with express mention of pension-like payments from the federal government in a parallel section, Section 3.4a, and the fact that in enacting that latter Section 3.4a in 1993, the legislature employed substantially different triggering mechanism. It was not just retirement allowance, but it was also retirement allowance or any similar payment which could embrace Social Security benefits. And it also added from the federal government. In fact, the legislative history of Section 3A indicates that Governor Weld first rejected the proposed Section 3A because it didn't specify that those who would be eligible, that didn't specify that you would be disqualified if you were entitled to Social Security. Now, here we were talking about particularly parochial teachers. It was colloquially referred to as the Nuns Bill because though they were not eligible for Social Security and they had no retirement provision whatsoever. And so legislation was passed that if they were not eligible for Social Security, they could purchase credit if they later became public school teachers for their parochial school experience.
I'm sorry. Your
Time is up. Ask the court defer to Crabb's decision here.
Good morning. May it please the court, my name is James Salvi. I'm counsel for the Appellee Massachusetts Teachers Retirement System. Your Honors, the entire point of Section 401P is to allow teachers who performed a public service by teaching special education children in the non-public schools to earn the same credit and get the same benefit that they would have received had they done that service in the public schools, but no more. The appellant's interpretation departs from this simple purpose and is incorrect for 4 reasons.
And you were incorrect until 2004, is that right?
Yes, that is right, because we followed the Attorney General's opinion, which was itself incorrect, and I'll address that. The first reason is it ignores the plain language of the statute, Section 401P. Number 2, it ignores the fact that in Massachusetts, Chapter 32 and Social Security are substitutes for each other, not complements, and that is the point, the ultimate point, of the amicus brief. In Massachusetts, a public employee cannot earn credit and get a benefit in both Social Security and Chapter 32 for the same work.
Without a statute
Without a statute?
that allows you to.
Without a statute that allows you to. And currently, well, certainly nothing allows you to, because this 218 agreement is an agreement between the Commonwealth and the federal government that essentially says that public employees in Massachusetts are enrolled in a state pension system, and it is an alternative to Social Security.
Could you give me a little bit of background information on a situation where a teacher in some other state has been teaching for, say, 15 years and has been contributing to that state's pension system, and then comes to Massachusetts? Can they buy into the Massachusetts system?
They can. Actually, that's Section 3.4.
Now, why can they do it but not somebody who's just gotten Social Security?
Well, that statute has very different exclusionary language. It excludes only a pension provided by the other state, period. Whereas, of course, this statute says provided by any other source. But I believe that the policy reason, Your Honor, is an attempt to increase portability and encourage teachers from other states to come here and essentially say to them, you will not lose the benefit that you have there. Whereas the point here with 41P is to provide to teachers in non-public schools in Massachusetts, it's limited to Massachusetts, who are teaching SPED students funded by the Commonwealth, and say you can get the same credit that you would have gotten had you done that important work in the public schools. The 218 agreement from 1935 to 1951, all state and local employees were excluded from Social Security. Beginning in 1951, it became optional by the state. These were 10th Amendment concerns. And each state could enter into an agreement with the federal government to say which of its employees it wanted to cover. It could cover all, it could cover none, it could cover some.
What if a teacher was coming from another state in which that state allowed contributions to, or paid contributions to Social Security in addition to its own pension? Can a teacher in that situation buy creditable service here?
Yes. If that were to happen, if somehow, Your Honor, they did not, well, if they were contributing, if they did not qualify for a state pension in the other state, but they did qualify for Social Security, they could still buy it. Again, though, Your Honor, the statutory purpose is very different, and the statutory language is very, very different. The point with Section 3.4 is to preserve the benefit in the other state. Come on over here to Massachusetts. You won't lose anything. Our state system will step into the shoes of your state system. But the point with 4.1p is to say to these people who are performing public service in Massachusetts, you just happen to be doing the same thing in a non-public school that we're now doing in the public schools, or trying to do in the public schools. Come on over. You can get this benefit. Because in 1973, there was a big class of people who were getting no benefit. People in these non-public schools who either were enrolled in Social Security but weren't going to work enough to earn 40 quarters and get a benefit.
Is that part of the record?
Yes, it's part of our argument. You have to be in... pardon me?
The numbers of people that were...
No, I'm sorry. The actual numbers of people are not in the record. I'm saying from the perspective of the legislature in 1973, there would have been a class of people, some of whom were enrolled in Social Security but not eligible for a benefit, and others who were enrolled in Social Security, who were not enrolled in Social Security at all. And this is a fundamental misassumption of the Attorney General's opinion.
But you're saying that this very expansive statutory scheme with different kinds of teachers from different states and who have different kinds of pensions actually are addressed, all those specific situations are addressed by the legislature.
There are different service purchase statutes for different kinds of scenarios. Some don't have any exclusionary language. They seem to be just enhancements. This one, though, has a broad exclusionary language, and it is different. Actually, I don't think that there is any service purchase statute in our statute that has an exclusionary clause this wide, except, of course, for Section 3.4a.
Well, what about 3.4a that talks about federal government and this one doesn't?
Yes. Your Honor, the appellant's argument presupposes that when the legislature is drafting 3.4a, they are adding this different language to a language that is the same or identical to Section 4.1p, and therefore, of course, it takes on added significance.
Well,
that
they definitely added language that isn't in 4.1p.
They did, Your Honor. But what they added it to was a draft, an earlier draft of Section 3.4a. That is in your record at page 231. And if you look at the words that they actually added and the words that they actually added it to, you will see that these additional words are not intended to be a different purpose for Section 34A. They are intended to have essentially the same scope. They are a refinement of the language of Section 401P brought about by the narrowness and deficiency of that initial draft.
So your view is that in 1993, the legislature intended the Attorney General's interpretation of 41P?
No, Your Honor.
But they would have, I mean, can't we infer, we usually do, that the legislature is aware of what's out there, and they would have understood that 41P had been interpreted by the Attorney General, and that interpretation had been governing what the retirement system had been doing.
Your Honor, I actually know of no authority that says that this court, and none has been cited, that says that this court is presumed to be aware of opinions of the Attorney General. The two authorities cite...
This court, I'm referring to the legislature.
Or that, I'm sorry, that the legislature is presumed to be aware of opinions of the Attorney
It's
General.
also the practice.
Also, the practice.
It was the practice. So the legislature chose language to mirror 41P when the practice under 41P at that time was contrary to what you're arguing here today.
But what they were adding it to, if the court would indulge me, I can walk you through very briefly through the actual language that they are adding and the actual statute that they're adding it to. And you'll see it is purely a refinement of what we are urging you is the scope of 41P. The original draft of 34A simply said, very unlike 41P, but the exclusionary language said it excluded retirement allowances paid by the non-public school, period. Governor Weld writes to the legislature, page 229 of your record, and he says, well, that's too narrow. That will include in the service purchase any retirement allowance paid by any source, including Social Security, other than from the school itself. So he suggests additional language, the federal government or any other source, making the statute, the resulting statute, excluding retirement allowances from the non-public school, comma, the federal government, comma, or any other source. Your Honors, that does not mean that the federal government is not a source. You would have to believe that the non-public school is not a source.
But if you look at Governor Wells' letter, and he says the purpose of this is to help people that didn't get any Social Security. I mean, it had a very specific purpose, 34A. I mean, I think it would be fair to infer that given that teachers and that for 20 years now 401P had been interpreted differently, that it really was trying to, it's a broader statute in terms of coverage. It was trying to solve a different problem. And if the legislature really meant 401P to say what you says it meant, they would have added the same language to 401P because they would know that it had not been so interpreted.
But what they added was...
At the same time, I mean.
What they added was to 401P. What they added to 34A was two examples and a catch-all phrase. So it reads the non-public school, the federal government, or any other source. Again, underlying the Attorney General's opinion, though, is a fundamental misassumption. And this was the authority that Crabb relied on, that the appellants have relied on. The Attorney General believes that our interpretation would vitiate the purpose of the statute because no one would be eligible for this.
But the reason that your client changed the interpretation, as I understood from its opinion, was that it was compelled to do so by the appeals court's interpretation.
No, not exactly, Your Honor. We did adhere to the Attorney General's opinion for a long time, as an administrative agency probably should, absent any contrary authority. The Dubé and Flaherty cases came out in 1999 and 2000, which caused us to have some severe doubt about the validity of the Attorney General's opinion. After all, the appeals court, although it was not a holding, the appeals court had no qualms about saying that a retirement allowance included Social Security.
But that was under 34A.
That was under 34A. But we did not change our policy based on those decisions. We waited until we adjudicated it, and the parties agree on this. We waited until 2004 when we adjudicated it, and a lawyer from our office made an argument in the alternative. and the administrative magistrate at the Division of Administrative Law Appeals, which is where we do our adjudication, agreed with that argument. Then we changed our policy, and we changed it only going forward. We did not do it retroactively. We changed our policy appropriately. Your precedents make clear that an agency can make policy, can reverse policy through adjudication or rulemaking at its choice.
But haven't you forgotten one more change between 3.4 and 4.1, which is that 4.1p says no shall be entitled to receive a retirement allowance, annuity, or pension from any other source, and 3.4 says shall be entitled to receive a retirement allowance or any other similar payment from the non-public school system, the federal government, or any other source. So why should we not interpret or any other payment to say Social Security may not be a retirement allowance, but it fits within that new phrase, and that new phrase is not found in 4.1p?
Again, I think that is just a refinement of language that was already in 4.1p. You can assume that they were aware of 4.1p, but it is simply a refinement of that language. 4.1p excludes a retirement allowance, annuity, or a pension. In 3.4a, they changed to retirement allowance or similar payment. Your Honor, I would suggest to you that there is no substantive difference between those two phrases, that they are both meant to capture retirement allowances, and it's catch-all language to capture other things just like retirement allowances, regardless of form of payment, regardless of nomenclature.
So you say your worry here is that individuals under 4.1p will be getting double credit. They'll be getting credit for these years toward their pension and credit towards Social Security.
There's absolutely no doubt about it. If you were
and they will get paid Social Security.
Yes, if you were to adopt the appellant's interpretation, there's absolutely no doubt about it. Whereas all public employees in Massachusetts, with the exception of some very, very small instrumentalities where they are not employed by the Commonwealth.
I understand that. The issue is whether they can get a state pension and also get Social Security as well.
And the appellant's interpretation would say, yes, they can, whereas if they did the exact same work in the public schools of Massachusetts, they couldn't. And everyone seems to agree. The appellants make the argument very, very well on pages 40 to 42 of their brief, that the purpose of Section 4.1p is to fill in a gap. That's the words of the Attorney General. It's to fill in a gap for a public service rendered but a benefit not provided. It's supposed to be equal, not better.
And what you're saying is all of these federal, the offset provision, et cetera, that doesn't wipe out the Social Security benefit?
Well, I don't see how the offset provision, the windfall elimination provision, which was created in 1984, could affect our interpretation of this statute enacted in 1973. The offset provision, if it has any relevance whatsoever, is yet another statement, now by a different level of government, the federal government, that they see an equivalence here between the state pension system and Social Security, that they are not complements to each other. They are substitutes. Your Honor, there are essentially...
So the end result, the practical end result is what? They won't really receive any Social Security benefit. That's the practical result of how these statutes now work, that this prior service, they're not going to receive a benefit from Social Security in any event.
They will get something. Even under the windfall elimination program, they would get something. Okay. But it would be reduced. I know I'm over my...
Whereas what you're saying is that teachers who were providing the same amount of work for that same period of time and were not paying into Social Security for that same work will not get even the reduced amount of Social Security.
That's right, Your Honor. They wouldn't get anything from Social Security because public employees, teachers, are not allowed to be enrolled in Social Security. They won't get anything. There is no escaping the fact that appellant's interpretation leads to double benefits, or if you want to take into account the windfall elimination program provision, 1.5 benefits. They will get more, even with the WEP. There are two pillars, if I'm not overstepping here.
You are.
I'm so.
Thank you very much, Your Honor.
Thank you.